Dear students, viewers, and the subscribers, welcome to the IAS Mentor. This would be lecture number 115 in the series, and we are looking into the topic of statutory bodies. So, we'll try to complete the statutory bodies today, and in the next class, I'll discuss about the executive bodies. Now, before I get into the topic, we are here to discuss some of the statutory bodies today. But before that, I would like to make this announcement to the students. In addition to the Indian Polity Series, we are also running a series on current affairs in relation to the subject Indian polity. And this current affairs for the subject Indian polity will cover the last 1 year of current affairs, especially to help the students who are appearing for the prelims 2024. So therefore, if you follow the Indian Polity Series as well as the current affairs series, your chances of getting 80 to 90% of the questions right in the UPSC examination is much higher. So with that, we'll enter into the topic, that is the statutory bodies. So let us try to understand the next set of statutory bodies in addition to what you have already seen. So in today's lecture, we are going to understand all these statutory bodies, that is the Central Vigilance Commission, the Lokpal, the Lokayukta, Bar Council of India, and the Delimitation Commission. So many of the years, the questions have been asked, especially the questions from Delimitation Commission has been asked in the prelims examination, questions from the Bar Council of India, questions from the Lokpal, they all have come in the examination. So we almost covered 10 statutory bodies. So we are trying to cover the most important thing. As I already said, what is a statutory body? A statutory body is something which is established by way of a statute. If it is established by way of a statute, then it becomes what is called as a statutory body. And in all these cases, you can see the Central Vigilance Commission is established by the CVC Act, Central Vigilance Commission Act. The Lokpal at the central level and the Lokayukta at the state level, they are established by the Lokpal and the Lokayukta Act 2013. The Bar Council of India is established by the Indian Advocates Act 1971. The Delimitation Commission is established by the Delimitation Commission Act 1952, and subsequently it has been amended number of times. So with that, we'll try to understand these bodies one by one. So first is the Central Vigilance Commission. So what is a Central Vigilance Commission? The very objective of establishing this particular body is to create a mechanism of vigilance in the central government departments and also in the public sector undertaking. And they will be vigilant enough to see whether any corruption is happening in the central government departments and also in the public sector undertaking. And their extent of vigilance is only related to certain areas of corruption, especially against the higher level officials. And apart from that, they also not only they are involved in investigating the actions of corruption or investigating corruptions in the government agencies, but primarily their objective is also preventive in nature. So they also take measures, proactive measures. They try to create awareness as to what will amount to corruption and take other measures to prevent corruption in the first place. So I would say that the vigilance mechanism is more preventive in nature, but they can also take up investigation related to the corruption matters. So this is basically what you'll have to understand. And they do not have any specialized investigating agency. In certain areas they can investigate, but in certain cases they can refer the matter to the CBI also and ask the CBI to investigate those matters. So to that extent, the Central Vigilance Commission might have the powers of superintendence over the CBI, especially when it is related to a corruption case against a government servant. So this is basically what you'll have to understand as the larger objective of the Central Vigilance Commission. As I already said, it is established based on the CVC Act 2003. So what is the purpose for which this is established? It can receive complaints on misuse of office or corruption, that is the vigilance activities for the central government, which also extend to the public sector undertaking. So before we look into the functions in detail, let us try to have an understanding about the composition of this commission. So if you see the composition, it consists of a Central Vigilance Commissioner and not more than 2 Vigilance Commissioners. So it has got CVC and plus 2 Vigilance Commissioners, and they are all appointed by whom? They are appointed by the President of India, and the President of India appoints them based on a committee, and that committee comprises of whom? That committee comprises of the Prime Minister, the Leader of Opposition in the Lok Sabha, and the Union Home Minister. So there's a 3-member body, and this 3-member body is the one who will recommend as to who is to be appointed as the Vigilance Commissioner and the other members, and basically they are the select committee. So based on which the president appoints them. Normally whenever they are appointed, the term is for 4 years or 65 years, whichever is earlier. So this is very important. So whichever is earlier is the important keyword that you have to remember, and there is no possibility of any further employment either under the government of India or under the government of any state. So hope you remember the difference between reappointment and further employment. Further employment means they cannot appointed in the government of India in any capacity. So that's basically what is called as further employment. And what are the grounds on which they can be removed? They can also be removed. They can be removed on the grounds of if they become an adjudged insolvent, convicted of any criminal offense, if they are engaged in paid employment outside the office, if they suffer from infirmity of body or mind, or on the grounds of misbehavior or incapacity. So this is almost the same ground that you have seen in case of the Human Rights Commission, that you have seen in case of certain other commissions like the National Commission for Protection of Child Rights. So here it is in case of the CVC also. So almost similar grounds in most of the statutory bodies. And apart from that, if you see their salary, allowances and their service conditions, they are all similar to that of the chairman and the members of the Union Public Service Commission. What will be the salary to the chairman of UPSC? The same salary to the chairman of the Central Vigilance Commission. Whatever is the salary to the members and other service conditions, similar to the members of the Central Vigilance Commission. So broadly, what is the objective of this commission is to carry out investigations with regard to corruption against the government officials, and also majorly to take preventive measures. That is what is a very important thing. So to that extent, what are the functions and what are their powers? Here you can understand they can inquire into allegation of corruption against the central government employees, especially against the Group A service officials and the All India service officers. Now today in our country, the All India service officers include Indian Administrative Service, Indian Police Service and the Indian Forest Service. So these are the 3 services we are considered to be All India services, and there are a lot of central Group A services. Say for example, Indian Revenue Service, the Foreign Service officials, or the Railway Service officials, the Postal Service officials, the Trade Service officials, the Account Service officials. They are all Group A services. So they can carry out investigation both against the Group A officers and the All India services. And of course, they can also carry out investigation again grade D officers in RBI, the higher level positions in RBI, and officers who are part of NABARD, the National Agricultural Bank of India, and then the scale 5 and above in the public sector banks. So scale 5 and above is a particular rank in the public sector banks. So they, and officers above certain rank and salary limit in PSUs. So here you can understand, as I already said, while the CVC does not look into investigation of all the government employees, it can inquire into certain officers of the highest rank, because the corruption can be at a larger scale at these highest rank. So at these levels, the CVC can take up the investigation, and sometimes they may refer the matter to the CBI also to further investigate, because the Central Vigilance Commission does not have a broader investigative wing as the CBI would have. So these are all some of the functions that is to be performed by the Vigilance Commission. And apart from that, if at all the matter is referred by the Central Vigilance Commission to the CBI related to the corruption cases, the CVC also have the power of superintendence over CBI on the matters referred to them under the Prevention of Corruption Act. So therefore, any corruption case which is referred by CVC to CBI, in those cases the CVC will have the power to supervise the CBI with regard to the investigation. And apart from that, vigilance administration in central government departments and PSUs, which means basically you will have to understand that apart from investigating, they also have the power to prevent. They will create awareness drives, they will create intelligence networks, so which are all in the first place will prevent the corruption in the respective agencies. So they will take care of all those things also. In order to enforce all those things, they have all the powers of a civil court, who the CVC. That means they can summon anyone, they can summon people, and they can take evidences on affidavit, and they can also call upon the officials to produce a public records. So all these powers are given to the Central Vigilance Commission. Now, primarily, you will have to understand as to how the Central Vigilance Commission is different from that of a body like Lokpal. So, why I am talking about this is now we are entering into a new statutory body, that is Lokpal and the Lokayukta in our country. In fact, there is a history behind this Lokpal and Lokayukta. So, the Lokpal is also considered to be today the highest ombudsman in our country to deal with the cases of corruption, who is the highest authority to deal with the issues of corruption against the government officials, and of course the other set of officials as well. And since 1968, based on the recommendation of the first Administrative Reforms Commission, the government after government, they tried to bring in a body which is called as Lokpal, a highest ombudsman. Ombudsman means who can adjudicate cases or disputes related to the corruption matters in the government authorities. Now, starting 1968, the government has been trying, and the first bill introduced to bring in a body like Lokpal in our country started in 1968. And after that, there were eight failed attempts in the parliament. So, 8 times a bill was introduced, but never it was passed. And then finally, it was passed in 2013, the Lokpal and the Lokayukta Act, which was majorly because of a movement which is called as the India Against Corruption movement. In 2013, because of the pressure from this particular movement, which acted as a pressure group, and then the subsequently then government of India has brought in this particular bill in the legislature, and then it was approved. Today we have a Lokpal and the Lokayukta Act 2013. Now, as per this Lokpal and the Lokayukta Act, at the central level there will be one body which is called as a Lokpal, and each and every state shall have an authority which is called as Lokayukta. So, every state shall have a Lokayukta. At the central level there is a body which is called as Lokpal, and the Lokpal would be the highest ombudsman at the national level to deal with the cases of corruption against a government servant. And the Lokayukta would be the highest body of ombudsman at the state level to deal with the issue of corruption against the state government employees. Not only the government employees, the others are also part of it. So, you can ask me, sir, already there is a body like Central Vigilance Commission. So, why do we need this Lokpal and Lokayukta? Now, try to understand the Central Vigilance Commission is only at the central level. It does not have any control over the state government officials. But whereas the Lokpal and Lokayukta Act provides for a Lokpal at the national level and the Lokayukta at the state level. This is one difference. But most importantly, the Central Vigilance Commission does not take up investigation against all the government servants. It is only catering to the corrupt activities of the higher level officials, the Group A officials, the All India Service officials, and officers above certain cadre and rank in certain other organizations. But whereas on the other hand, the Lokpal and the Lokayukta Act allows the Lokpal to have control over all the government officials, Group A, Group B, Group C, Group D, all the officials, they can be made accountable if they engage in corruption. Not only against all the government officials, but also it includes the union ministers, including the Prime Minister of India. Although the Prime Minister is exempted in certain cases, there are exemptions, but yes, in general he is also under this thing. And apart from that, there are also certain other exemptions. Say for example, I think the defense officials are excluded from this, but otherwise most of the people are brought within the ambit of what is called as Lokpal, including the members of parliament. And similarly at the state level, all the government officials, Group A, B, C and D are within the ambit of Lokayukta, and including the Chief Minister and the Council of Ministers. And apart from that, the members of the state legislature also are within the ambit of what is called as Lokayukta, especially in matters related to what is called as corruption. So, this is basically what you will have to understand. So, while the jurisdiction is much larger when it comes to Lokpal and Lokayukta in comparison to the Vigilance Commission, but the Vigilance Commission also has a preventive role. But in case of Lokpal, there is no preventive role. Lokpal only investigate the cases, and based on the investigation, they can punish the individuals. So, based on the trial that is conducted in a court. So, this is basically what is the difference between the Lokpal, Lokayukta versus what is called as the Vigilance Commission. Alright, so before we look into the functions of the Lokpal in a more detailed manner, let us try to understand about their composition. So, basically what is the objective of Lokpal? The objective of Lokpal is to prevent corruption in the government agencies. So, therefore, there is a composition that is given under this particular Lokpal Act, which talks about that the Lokpal shall consist of a chairperson and 8 other members. And the chairperson should be whom? It should be a retired Chief Justice of India or a retired Judge of Supreme Court or an eminent personality. So, any of these categories of people can be appointed as the chairperson of Lokpal. And apart from that, whoever is a member who is appointed here, 50% of the members should have a judicial background. So, that means they should have a background from the judiciary. And 50% of the members should be having a background either from the scheduled caste, scheduled tribe, other backward caste, minorities and women. So, this is how the classification is given, so that the membership in the Lokpal is inclusive of most of the sections in the society. So, according to which they can function. So, that is the idea, that to make it more inclusive, this kind of representation is given. Most importantly, there is a selection committee, because all the appointments will be done by the President of India to the Lokpal. But the President will appoint only those members whose name is recommended by the selection committee, and that selection committee will have 5 members headed by the Prime Minister, the Speaker in case of Lok Sabha, leader of opposition in the Lok Sabha, the Chief Justice of India or any other judge of the Supreme Court, and then an eminent person who is appointed by the President of India. So, all these 5 categories of people will be part of a select committee, and this select committee will recommend the names to the President, and then the President will appoint the chairman and the members of the Lokpal. And whenever they are appointed, their term is usually for a period of 5 years or 70 years or till they attain 70 years, whichever is earlier. So, these are all some of the features probably you may have to remember for your prelims examination, like the select committee, like the term, like the composition, who shall be the members. So, all these things can be asked in your prelims examination. But as a student preparing for UPSC, you should also be aware of the jurisdiction of Lokpal. That means in which nature of cases the Lokpal can come into effect, especially in matters related to corruption, but who are all may be taken up by the Lokpal, or against whom the cases may be taken up by Lokpal. It includes the Prime Minister, the other Council of Ministers, MPs, the central government officers including Group A, B, C and D. So, almost everybody is covered, but however, there are few exceptions. So, what are the exceptions? In case of decision taken by the Prime Minister in relation to international relations, or which is related to the external and internal security of India, or related to public order, or related to atomic energy or space, in these cases, if the decision is taken by the Prime Minister, and any matter where the Prime Minister is involved, which is in relation to all those things, and if there is an allegation of corruption, in those cases the Prime Minister may have an exception, but in that case also the Prime Minister can be prosecuted, or the case may be taken up by the Lokpal, but it can be taken up only if it is approved by 2/3 of the members of the Lokpal. So, if you see Lokpal, the Lokpal has got the chairman and 8 members. Out of this 9 members including the chairman, at least 6 members should say that yes, this case should also be taken up by the Lokpal. So, then only it may be taken up by the Lokpal, otherwise it may not be taken up by the Lokpal. So, is it clear to all of you? So, try to understand. So, these things are very important. So, first of all, the Lokpal has a broader jurisdiction. It can take up cases related to corruption against anyone including the Prime Minister. But in certain cases the Prime Minister may be exempted, but in this case also the exemption is overruled if 2/3 of the members wanted to take up the case against the Prime Minister. So, these are all some of the important provisions of this particular act. Alright, so what is the power and how the enquiry is taken up by the Lokpal? Now, the Lokpal does not have any power to take up suo moto any case. The Lokpal may take up the case only when a complaint is filed. So, against whom the complaint can be filed? It can be filed against the Prime Minister, the Council of Ministers, the MPs, any of the government officials at the central level. Subject to the exceptions, the others are all within the jurisdiction of the Lokpal. So, whenever a case or a petition is filed in front of the Lokpal will prima facie see whether there is a case. It will do a preliminary enquiry. So, therefore, it will refer the case to what is called as an enquiry wing. They will do a preliminary assessment of that. And if they find that yes, there is a case in this particular matter, then they will refer the matter to what is called as the further investigation. And the further investigation may be taken up either by the Lokpal, or they can refer the matter to the CBI also. Because the Lokpal does not have any investigating agency, a broader investigation authority of its own. So, it can take the help of CVC, it can take the help of CBI in this particular regard to do a detailed investigation. And then the matter is taken up by what is called as a prosecution wing. The prosecution wing is the one who, after the charges are framed, after the investigation is over, after the charges are framed, It is a prosecution wing who will take up the matter to what is called as a court. A special court will be established for this particular purpose, and in the special court the prosecution will be done. So this is how normally it happens. So try to understand, in case of Lokpal there are two important departments. One is an enquiry wing and other is a prosecution wing. The enquiry wing will do up to the investigation, and after the investigation it will be given to the prosecution wing, which will basically consist of the lawyers and other people, and they will try to prosecute the person against whom the case has been filed with the Lokpal. And where the prosecution will happen, it will happen in a special court which is established for this particular purpose. So this is basically what you will have to understand. And in the special court, if the individual is found guilty of the corruption, then the special court will give the punishment. So this is basically what you will have to understand, but the prosecution wings works under the direction of the Lokpal. And to that extent, the Lokpal also has supervisory powers over CBI and CVC whenever the Lokpal refers a matter to the CVC or the CBI to make the investigation. So in those cases, the Lokpal will have supervisory powers over them. The Lokpal has a power to search and seize the documents during investigation against any individual, so that can be done. The Lokpal has all the powers of a civil court to summon anyone. The Lokpal also has a power to attach the property of a person against whom an allegation is there. So even during the allegation, even during the inquiry, even during the investigation, the property of an individual can be attached by the Lokpal, so that is their power. And the Lokpal also has a power to punish for any false complaints. If with malicious intention somebody is filing a false complaint, so then if the Lokpal finds out this is a frivolous or a false complaint, then the Lokpal can punish for that as well. I said that the Lokpal also has a power to attach the property, which means the Lokpal can attach the property of an individual. So therefore, pending this prosecution, pending the matters disposed by the court, the individual will not be able to sell that particular property, or he cannot transfer the title deed to anyone. So that is not possible. He has to be cleared of this particular case, then only he can use this property. So till the time the Lokpal can attach the property. So all these things are some of the powers which is given to the Lokpal. So try to understand. Now Lokpal is to act as a highest level of ombudsman or a highest anti-corruption body in our country, which has got a broader jurisdiction, and therefore it can also prosecute the individuals and punish the individuals for their corrupt activities. However, there are some element of criticism with Lokpal also. First of all, it is said the Lokpal has no suo motu powers to take up the cases. Secondly, the Lokpal does not have any investigating authority of its own. It is heavily dependent upon either CVC or CBI, and a lot of other rules as to how the Lokpal will function, how they can entertain the cases. In all these cases, it is a central government which has to prescribe the rules. So therefore, these are all some of the elements of criticism of the Lokpal, but yes, still it is a very right direction, it is a very important step in the right direction to deal with the issue of corruption in our country. A similar function, whatever is done by the Lokpal, is done by the lokayukta at the state level. So they are to prosecute the officials on whom the corruption charges are there at the state level. But however, the questions may not arise from lokayukta, but Lokpal is very important. So try to have an understanding of the Lokpal. So with that, we'll move to the next topic, that is the Bar Council of India. Very, very important topic. UPSC of late has asked question from the Bar Council of India. Now, what is the status of Bar Council of India in our country? The Bar Council of India is also a statutory body, and the Bar Council of India is established based on what is called as the Advocates Act 1961. So anything that is established by law is what is called as a statutory body. In fact, it was way back in 1951, the Law Commission of India has recommended, and then subsequently the other recommendations also happened, and subsequently the Advocates Act was established, based on which the Bar Council of India is established. So today, if you see the Bar Council of India, the Bar Council of India has certain important functions to perform. So what are the important functions that is to be performed by the Law Commission of India, the Bar Council of India? Now the Bar Council of India has two important functions to perform. One is the Bar Council of India will specify as to what shall be the rules to be followed in various matters related to the legal matters. Or to be very specific, the Bar Council of India is authority to give sanctions to various law colleges in our country. And also the Bar Council of India is the one who will prescribe the various rules related to the syllabus which is to be followed in various law colleges in our country. So that's one important area where the Bar Council of India plays a very important role. So apart from that, the Bar Council of India may also specify rules as to who can practice in our country. So these are all some of the important powers which is given to the Bar Council of India. So it can be considered to be a regulatory body when it comes to the law profession as well as the law studies in our country. And for this, there is a commission, a multi-member body, which is the Bar Council of India. What shall be the composition of Bar Council of India? The composition of Bar Council of India includes a chairman and a vice chairperson and certain other members and certain other ex officio members. So you don't have to remember all the things. So it is a multi-member body, that is sufficient. One member elected by each state Bar Council of India among its members. So similar to that of the Bar Council of India, there is also state Bar Council. So from various state Bar Council also there are representation in the Bar Council of India. And apart from that, there is a chairman and the vice chairman who are elected from among the members. And of course, it has got certain ex officio members also. Who are the ex officio members? The Attorney General and the Solicitor General of India. So who is Attorney General of India? He is a top law officer of our country. And to help him, there is a Solicitor General. So they are also ex officio members of the Bar Council of India. So try to understand, it consists of a chairman, a vice chairman, certain members and certain ex officio members. So who are the ex officio members? It is the Attorney General and the Solicitor General. Who are the members? The members comes from the various Bar Council of India. And from among the members of the members come from the various state Bar Councils. And among the members of the state Bar Council, one person is elected as a chairman and other is elected as a vice chairman. And there are remaining members, and of course they got ex officio members as well. So whatever is the term, their term is usually for a period of 2 years, and they are largely responsible for regulating the legal profession and the legal studies in our country, that is in relation to law in our country. So this is basically what you'll have to understand. So I have given the quick functions, you can just go through it. They lay down the standards for professional conduct and etiquette of advocates. They lay down the procedure to be followed by the disciplinary committees. They safeguard the rights and privilege of interest of advocates. General supervision and conduct over the state Bar Councils. They promote legal education and lay down the standards for legal education in consultation with the universities. They promote and support law reforms. They organize legal aid to the poor people. They recognize universities whose degree in law shall be qualification for enrollment as advocates, to conduct seminars and organize talks on legal topics. So all these things are done by what is called as the Law Commission of India. Sorry, not the Law Commission, sorry, the Bar Council of India. So I am sure that you are aware of all those things. In fact, what is the Law Commission of India, I will subsequently discuss, because Law Commission of India is not a statutory body. It's a body established by an executive order, which I'll subsequently discuss in my next lecture. So these are all the major functions that is performed by the Bar Council of India. And before I complete this lecture, we have one more important statutory body, that is the Delimitation Commission of India. In fact, I have discussed elaborately about the Delimitation Commission earlier also when I was discussing about the Parliament, state legislature. But for the students who are watching this lecture directly, I'll also discuss. What is this Delimitation Commission? It is a Delimitation Commission which is a specialized body in our country which will delimit the boundaries, which will decide the number of seats for the various states in our country in relation to the Lok Sabha seats, in relation to the Legislative Assembly seats. All these things are done by the Delimitation Commission. For example, what is the function that is performed by the Delimitation Commission? To understand that, we will have to understand as to what is given in the Constitution. If you see the Constitution does not give the exact number of seats to be there in the Lok Sabha, the exact number of seats to be there in the Legislative Assembly. None of these things is directly given in the Constitution. It is only said that the number of seats or the number of constituencies for every state and for the every state in the Lok Sabha elections and also in the Legislative Assembly elections, they all to be determined based on the law that is passed by the Parliament. And accordingly, the Parliament enacted, it all shall be determined by a commission or a body which is established by the law made by the Parliament. Accordingly, the Parliament enacted what is called as a Delimitation Act. And based on the Delimitation Act, they established what is called as the Delimitation Commission. And today this Delimitation Commission plays a very important role in determining all those things. In fact, they play three important roles, but the Constitution categorically says that whatever the body that will be established by a way of a law that is passed by the Parliament, and which is now the Delimitation Commission, so they shall determine the number of seats, they shall draw the boundaries, and they shall also reserve the seats to the scheduled caste and scheduled tribe. But all these things are to be done based on the population. So what is the basis on which all these things is to be done? They are all to be done on the basis of population. So this is a very important thing. Accordingly, this Delimitation Commission was passed in 1952, then again in 1963, then in 1973, then again in what is called as 2002. So there was a question in UPSC examination, how many times the Delimitation Commission was established in our country till this point of time? It was established 4 times. So what are the functions that they perform? Don't forget, they have been established 4 times in our country till this point of time. And if you look into the composition of Delimitation Commission, the Delimitation Commission is headed by a chairman and 2 members, and the chairman is usually a retired judge of a Supreme Court, and 1 member is either the Chief Election Commissioner or any of the other election commissioners, and the third member, the second member, the third person, the second member is someone who is a state election commissioner. So whenever they go and delimit the seats for different states, the respective state election commissioner will be part of it. In addition to that, they have a lot of ex officio members. That is not very important, but just try to remember at least these 3 members. And what are the main functions they are supposed to perform? First and foremost thing is they are to determine the number of seats for each and every states, or they are to determine the number of constituencies for each and every state, both Lok Sabha as well as the legislative assemblies. So for example, in case of Uttar Pradesh, in Uttar Pradesh there are 80 seats to the Lok Sabha elections. Who will determine 80 seats to Uttar Pradesh? That is determined by the Delimitation Commission. In case of Tamil Nadu, it is 39 seats. Who has determined that? It is done by the Delimitation Commission. But what is the basis on which the Delimitation Commission has to do that? On the basis of population. And what population is followed for that is the 1971 census. And this 1971 census is likely to be followed till the first census is published after the year 2026. So whenever the first census will be published after 2026, then they can follow the latest census. But till that point of time, they are likely to follow only the 1971 census. And based on 1971 census, the seats are allocated. That is why today, a number of southern states are having issue with the new delimitation process, which is initiated by the central government, because the new delimitation process might take into account the first census after 2026. If they take into account the first census after 2026, then naturally the southern states are having less population in comparison to that of the northern states. So therefore, there is a possibility that the southern states might go for a reduction in the number of seats. So that is a fear that is there in the minds of the southern states, which may be true, may not be true. But one of the primary function of the Delimitation Commission is to determine the number of seats, and presently it is done based on 1971 census. And not only to determine number of seats from every state, but they are also supposed to draw the boundaries of each and every constituency. Suppose if there are 80 seats in the state of Uttar Pradesh, that 80 seats should have a territorial limit. So because only when you know the territorial limit of each and every constituency, the Election Commission of India can prepare the electoral roll, so based on which the elections can happen every constituency. So therefore, they should draw the boundaries of every constituency, and who will draw the boundaries of every constituency? That will also be done by the Delimitation Commission. And for this purpose, the census that is used is 2001 census. And this 2001 census is likely to continue till the time the first census is published after 2026. Now, the third function that is performed by the Delimitation Commission is that they shall also reserve the seats for the scheduled caste and scheduled tribe in every state. And what is the basis on which this has to be done? This shall also be done on the basis of population. And what is the population that is taken into account for this purpose? It is the 2001 census. Now, the Constitution says the number of seats that is reserved for the scheduled caste and scheduled tribe in each and every state should be in proportion to their population. Suppose in Lok Sabha, in case of Uttar Pradesh, there are 80 seats. Out of these 80 seats, if there are 10% population of the scheduled caste, then 8 seats has to be reserved to them. to the scheduled caste population. 5% is the population of scheduled tribes, then 4 seats has to be reserved for the scheduled tribes from among the 80 seats, and the remaining seats will be general constituencies. So, who shall determine all those things? It is all to be done by the Delimitation Commission as per the 2001 census. And for that particular thing, we have already seen the composition. It consists of whom? A retired or a serving judge of a Supreme Court, the Chief Election Commissioner or any other election commissioner nominated by CEC, and the State Election Commissioner of the concerned state. And this Delimitation Commission has been given a very important power that the orders of the Delimitation Commission generally cannot be challenged in a court of law. So, that does not mean that there is a complete immunity or a complete ban from judicial review against the orders of Delimitation Commission. The Supreme Court has also made it very clear. So, generally these orders cannot be challenged. But if there is a malified intention within which a Delimitation Commission has passed the order, or the Delimitation Commission in publishing these orders, deciding the number of seats or the boundaries, they have not followed the proper procedure, or they have a vested interest in doing the mistakes. So, in those cases, if there is a malified intention or a procedural irregularities, still the matters can be entertained by the courts. So, do the orders of Delimitation Commission subject to judicial review? Generally not, but still the orders can be challenged in a court of law, or the orders may be subject to judicial review on the grounds of malified or on the grounds of procedural irregularities based on which the orders has been published in the first place. So, this is basically what you will have to understand with regard to the Delimitation Commission, a very, very important topic. I am sure that you can understand now what is the role of Delimitation Commission. 3 major functions. One is to determine the number of seats, draw the boundaries, reserving seats for the scheduled caste and scheduled tribe. Number of seats based on 1971 census, drawing the boundaries and reserving the seats for the scheduled caste and scheduled tribe based on 2001 census. In all the cases, it is still the first census is published after 2026. That means after the first census is published after the year 2026, then any delimitation process that will happen after that will be based on the latest census. So, till the time it will be based on the census year that I have told you. So, this is basically what you will have to understand, and till this point of time, how many times the Delimitation Commission has been established? 4 times. Is the order of Delimitation Commission subject to judicial review? Generally no, but on specific grounds of malified or on the grounds of procedural irregularities, yes, it can be challenged in the courts. So, this is basically the information that you should know with regard to the Delimitation Commission. So, with that we are coming to the end, but before that we will discuss this particular question. Consider the following statements. The Bar Council of India has a power to designate an advocate as a senior advocate. Is it possible for the Bar Council of India to do that? In fact, I have discussed about this during the topic of judiciary, who can designate an advocate as a senior advocate. The Bar Council of India can lay down the standards for professional conduct and etiquette for the advocates. Is it true? During the functions I have read out a similar function. The Chief Justice of India is ex officio chairman of Delimitation Commission. Who is the ex officio chairman of the Delimitation Commission? So, try to answer that. In fact, for the Delimitation Commission there is no ex officio chairman. So, anyways this particular statement is wrong. Which of the statements given above are incorrect? So, definitely 3 is wrong. It should be either A or B. Try to put your answers in the comment box. Alright. So, with that we are coming to the end of the lecture, but before I end the lecture, in addition to the Indian Polity Series, we are also doing a series on the Indian polity related to the current affairs, which could be really beneficial for the students appearing for the prelims 2025. So, if you know any of your friends appearing for the prelims 2025, you can refer the current affairs series for the polity. So, thank you very much and all the very best.